Yes, before the adjournment, I was dealing with the amendment to rent-account document.
Yes.
And I think I got to the stage where I was suggesting that the text of that document and its timing permits an inference to be drawn.
Yeah.
That it wasn't a purely internal document, but that it must reflect some deliberation or agreement or conversation between the landlord and tenant. And the first point we'll make about that is that it refers in its text to parties and agreements, and the rubric joint to sole would suggest that it is reflecting an agreement, and the obvious parties to that agreement would be Mr. Hussain and Mr. Kazan. So there is the document is consistent with it reflecting an agreement.
Can you really get that out of it? Because it is a change in the parties. It's headed parties and agreements.
Well, that's true, but since such a change would only be made following an agreement or following some, at least a request, it certainly suggests that there has been, it goes to this being a document that isn't purely internal, but which reflects some communication between them.
I mean, the request we know about, effectively, is that from Mr. Kazan.
Yes, well, he's yes, we know about that, but this is 2 months after that.
But there are two separate questions, aren't there? One is the document internal, to which the answer must be yes.
Yes.
The second is, which I think is the one you're addressing, is the document evidence of some external agreement which gave rise to the entry on the document?
Yes.
And that's really the inference that you are asking us to draw, although I don't think it's one that was drawn by the trial judge, who indeed said that there was no real reliance on it.
Well, the trial judge didn't really address this point at all. The trial judge made an implied finding, for the reasons I said, that there was a grant of fresh tenancy.
Yes, but not based on this document.
No, indeed not. But what and it's important that I emphasise why we're having this discussion, which is that it's to in support of the argument that Mr. Justice Lane was wrong to say that there was no evidence before Judge Hellman, and to support the inference of a fresh tenancy.
Well, was Mr. Justice Lane asked to draw the inference from this document that it was evidence of an agreement?
I don't know if it was put to him in exactly these terms. I understand it was relied on below, but obviously in broadly the sense that I'm putting it to the court, which is that it spoke to or was evidence of some agreement between the parties. We don't have a transcript of the appeal here.
Yeah.
But in one sense, it perhaps doesn't matter, because where this point is ultimately leading is that if there was some evidence that would support the finding of an inference of tenancy, then the proper disposal of this court is to remit them.
Just before you move on, so I understand that the bigger picture, you've referred earlier to the fact that there was precious little documentation, and made the point, without, as you say, without making a criticism, that there wasn't much disclosure from the local authority. Was there an order for disclosure?
Not as far as I know. I'm told there was an order for standard disclosure, and this is a fast-track trial.
There was an order.
There would simply been standard disclosure.
Yeah.
And so there wasn't any further application for disclosure, as I understand it.
But that, on the face of it, should have encompassed all documents that were adverse to the council and could help you.
On the face of it, yes, but it's clear that there would have been other documents, but they clearly weren't disclosed. And we do say that in those circumstances, the court to resist drawing the broadest inferences it legitimately can on material like this would be to reward bad record keeping, and it ill behoves the Westminster to come to court and say, well, here's our internal document. It shows we treated Mr. Sane as a sole tenant, but the records we're disclosing don't show that she was a party to that, even though it says agreement.
Is the document on page 26 any indication that there might be other documents? Because it refers in the fourth line to Mrs. S. Hussain, 18th of October 2020, and the previous date's 2005, 1998. And then it refers to another drive. It's a short entry, it appears. So I don't know if that might have given any assistance.
I'm going to come to the significance of the change in the rent account, which is what that reflects.
Yeah.
But the further points that I rely on in relation to the amendment document, I've dealt with the agreement, but I do rely on timing, because it's 2 months after the communications from Mr. Kazan, but 2 days before he went on the waiting list, or before his application under the waiting list happened. And although we have the documentation from Mr. Kazan that you've seen, the letter to housing benefit and the application, it doesn't in terms ask him to be taken off the rent account, which suggests that there was something in between, and suggests that there is some link between this document and Mr. Kazan's application to the waiting list, which is 2 days later. And we also find in the agreement, although this is an internal matter, that the council's officer requests that Mr. Kazan be removed from the rent account in furtherance of the agreement recorded there. A further point we rely on is that the change is expressed to take effect from the 1st of August 2011, which is a Monday, and Monday is the rent day under the tenancy. So it appears to be intended to mesh with the periods of the tenancy.
Doesn't it more likely mesh with the date it was signed off by the estate director?
Well, it's the we don't know. Well, that is possible because without being a handwriting expert, it does look a little bit like the estate director's writing is the same as the bit on the effective date, but the point would remain. It would be open to the estate director to give a different date.
Yes, of course.
And it is the case that the 1st of August 2011 was a Monday, and it's also the case, we see this from page 11 of this bundle, that the Mondays were a rent day under the tenancy.
Well, we don't know, do we, where Mr. Kazan was between August 2011 and the date in 2012 when he was rehoused?
No, we don't. Again, that would be something that would have been in the possession of the authority.
Well, not necessarily.
Well, they would know he'd made a homelessness application, so they would have had some record of it. He certainly wasn't at this address. He was either a temporary accommodation provided by the authority, or he was still with his daughter.
Was any of this explored with the council's witness? I mean, on the face of it, if you had a case that a tenancy was granted by the council and that there were communications giving rise to that between the council and Mrs. Hussain, that ought to be put to any witness called by the council.
Well, my lord, that's certainly there questions could have been put, further documents could have been disclosed, but the trajectory that this case takes to this court is we have to remember one where the appellant succeeded before His Honour Judge Hellman. So it's not a case where the appellant's trying to adduce extra evidence on a case that they lost. It's one where they're trying to explain or to say that there is further evidence to support a finding that initially was made in their favour.
But, well, if it was your case before Judge Hellman that a tenancy was granted, that ought to have been put.
Well, that case was put. It's fair to say that it wasn't put with the sophistication that's being applied to these documents.
And put to the witness.
It wasn't put to the witness.
Although Miss Nwozu did sign the form.
She did, and she gave
She
evidence.
was called.
She was called.
She was cross-examined. We've got a transcript of the cross-examination at pages 51 to 53, and she's not asked anything about this.
No, she says that she wasn't the housing officer at that date.
But she was, surely.
Well,
Witnessed by HO, and that's her, isn't it?
That's what the document appears to say, but her evidence was she wasn't the housing officer then. But my lord is quite right that she wasn't cross-examined on this document. But none of which we suggest prevents us from saying, well, look, when one looks at the material, looks at all the inferences that can be drawn from, then there is evidence from which and that's the point. It's not whether this court would draw that inference, but the question is whether there is evidence from which the inference could be drawn. And it's the kind of point which is properly one for the county court, because they are familiar with the types of information that one would expect to find in a case of this kind. Which is why, if this court is tempted to say, well, we're in as good a position as the county court would be because this is all documentary, that's not the case, because the county court's got particular experience in these kind of cases. Just a couple more points. No, one more point, I think, on this document, which is that it is, as has been pointed out, signed by the estate director, and purported to be signed but witnessed by the housing officer, but which does suggest that it's intended to have some formal effect. It's not simply a casual note. It's something which is a formal document, even if it's one which, on its face, appears only to be an internal record that will be kept. But it's the kind of document, again, that one might have expected would be reflected in some confirmatory correspondence with the parties. It would be surprising if the only thing that ever happened was some oral communication, or even on the council's case, no communication. The council then does this unilaterally and then doesn't confirm anything. That would be an extraordinary way for a well-run council to proceed. The next thing that we know happened, and this was in Ms. Lewis's evidence, was that Mr. Kazan was removed from the rent account, which is, again, a critical matter for two reasons. Firstly, one has really to reflect on what the rent account means. When you remove somebody from the rent account, it means you're removing from the tenancy. Removing from the tenancy, because it's senseless to say, well, we're removing you from any obligation to pay rent, but we're in some ghost-like way keeping you on the tenancy. And so it's, in effect, a paraphrase to saying we're taking off the tenancy, which reflects what's said in this form. And thereafter, when we go to the document at page 26, it's clear that the only person named as the tenant is Mrs. Hussain. And she, from that point on, appears to have taken sole responsibility for the rent. There's no evidence that Mr. Kazan was ever pursued for the rent or ever treated in any way as a tenant thereafter.
In the column tenancy, does the 2005 refer to the date when the tenancy was granted?
That is the date of the original tenancy. Yes.
Sorry?
That's the date of the original tenancy. So
Yeah.
It's not the date of what we say is the sole.
No, I follow. So the date, the start date of the original tenancy remained the same.
Yes, but again, we don't have an explanation for this. One hasn't been given. I of course accept the point that it's something that Musu could have been asked, but it may well be that this form reflects the occupation date rather than continuous tenancy date. But of course, she subpoena a secure tenant from that date. But the further point about changing the rent account is that it tells us more about what notice was given of this change to the parties. Because what then happens is, as far as Mrs. Hussain is concerned, is that any notices of rent increase or any rent statements, and the normal practice is that they're produced quarterly, would have gone to her alone. And so if one is asking about what objectively she knew and what objectively her intention is, from this point on, she would have known that the only material, the only person mentioned on those documents was her. And that's the minimum that must have happened. And in addition to that, any variations to the tenancy would have come out in her name, any correspondence about the tenancy, anything about repairs, anything about neighbour issues, anything about neighbourhood issues, would all have gone to her as tenant. And so from that, even if one can't infer that she had knowledge of or was a party to some agreement reflected in the change document, the fact that she was then the sole tenant means that she was then the only person on the rent account for which read tenancy, means that any documents or any communications would come to her alone. And of course, they wouldn't go to Mr. Kazan. So the mirror image at that point is that Mr. Kazan would also have been aware that that's what was happening. So when you put all that together, and you bear in mind the point I've made, the general point I've made about inference in a case like this, where documents haven't been produced by the party who has them. We have knowledge on the part of all parties about about the fact that Mrs. Hussain is being treated as a sole tenant. We have a clear indication internally that Westminster is treating her as a sole tenant, and strong grounds to infer that reflects some agreement between the parties. And that going on for a very significant period of time, because the arrangement took effect in 2011, and Mrs. Hussain didn't die until 2020. And through all that time, she was treated as the sole tenant. And I start with, or I go back to the point I started with here, which is that the whole tenor of these arrangements is that they are intended to change something. It's intended to change from a joint tenancy to a sole tenancy. And the only way that could have happened was by granting a fresh tenancy to Mrs. Hussain, because in the circumstances they chose not to serve a notice to quit, when, as my lords pointed out, that is something that local authorities very often do, and they could have done it. Or rather, they chose not to invite a notice to quit, and then a further grant. And they chose this method, and at some point the point is made that, well, it could be referable to an assignment. But that is wrong as a matter of fact, and also poses the wrong question. Because, as a matter of fact, there's the only type of assignment that would have been effective here, or could have been effective, would have been under Matrimonial Causes Act, for the reasons I mentioned earlier. And on that, the case I was referring to, which I'd lost the reference to, is Wilson and Harrow, which is EWHC 1574, 2010, which is it was a case where the point was raised but not finally decided. But there's no suggestion there was any such assignment, and so it can't be said that that was part of the factual matrix that the parties had in mind. But it's also wrong, or because it misses the point, because the question we're concerned with here isn't the one that might be addressed in asking whether conduct is only referable to the non-continuation of the old tenancy. So in other words, it's not directly the surrender question, but it's simply the question what inference should be drawn from all the facts. And so the fact that there are legally two potential ways in which a tenancy could go from joint to sole is neither here nor there when one is asking yourself, is there evidence to support the grant of tenancy? So, Lord, for all those reasons, we say that whatever the may be made ultimately for all of this, and whatever this court would be inclined to decide, it's quite impossible to say that there's no evidence that would support the grant of a tenancy. So far as Mr. Kazan's assent is concerned, if he's treated as a non-participant, it can be inferred.
Sorry, just let me just recap on this bit. You accept, I think, that Judge Hellman did not draw the inferences that you are asking us to.
No, you can't find any of this discussion in his judgment.
Right. So does that mean that, so to speak, it is up to us for the first time to draw what we consider to be the appropriate inferences rather than reviewing inferences drawn by the trial judge?
No, because the way that this case progressed is that the appellant succeeds in front of His Honour Judge Hellman, and part of that is an implied, but I accept completely unreasonable decision that the appellant was granted a sole tenancy. That, on appeal to Mr. Justice Lane, is dealt with by Mr. Justice Lane on the basis that there was no evidence, among other things, that there was no evidence to support any conclusion that there was a sole tenancy. If this court decides that there was evidence to support it, then it's not for this court to decide that issue itself, but the matter should be remitted.
Right.
And that really brings me on to my final point, which is disposal. And I think I probably have said what I intend to say on this. But the question for this court isn't what is the right answer, was there evidence? That's preeminently a matter of the county court, and that leans in favour of remittal in this case. This isn't a case like the MasterCard case where there simply was no evidence at all to support the claim, but the Court of Appeal remitted it anyway. Our argument here is predicated on there being evidence that would support the finding.
Yeah.
Before I move on, I've just got a couple more points just to, can I just check if I'm missing anything? My Lord, that concludes my submissions, apart from 2 points where I want to pick up a couple of points I made earlier. The first is that when discussing assent to an act by a joint tenant, I mentioned that the seriousness of what is at stake may be something that you could take into account. But I do want to stress that one mustn't then fall into the trap of treating that as implying some kind of heightened sense of burden of proof, or which would be contrary to cases like B. All we're really saying is that given the seriousness, then there might not be actual assent if there's simply casual words being used or something like that. And the second point is that if assent like that can be inferred, and again one mustn't lose sight of that, it can be inferred, if necessary, from non-acquiescence, as in Metcalfe and Boyce, and as recognised by Mr. Justice Morgan in Singh. But would you bear with me? My Lord's answer to anything.
No, thank you.
Thank you very much, Mr. Westgate. Yes, Mr. Grundy.
My Lord, my Lady, my learned junior, who's dealt with this throughout to this point, is very concerned about the shifting sands of the appellant's case. What I'm going to do is take you to what His Honour Judge Hellman found, and what His Honour Judge Hellman said was the way in which the appellant's case was being presented to him. And that's in the core bundle at page 126, which is behind tab 11, and it's paragraph 44. Miss Paris, on behalf of the second defendant,
Sorry, which
that's Mr.
paragraph?
Rahimi, the appellant.
Sorry, which paragraph?
44, right at the bottom of the page, my lord. Miss Paris, on behalf of the second defendant, submits that the first defendant, that's Mr. Kazam, or Kazom, surrendered the tenancy by operation of law. She submits that Miss Hussain agreed to the surrender and that the claimant accepted the surrender. She submits a new tenancy of the same property was granted to Mrs. Hussain by operation of law, and therefore Mrs. Hussain was not, at the time of death, a sole surviving tenant under the original tenancy. Miss Paris then becomes Miss Callis. I don't know if she has a great singing voice. Miss Paris submits that the second defendant succeeded to the new tenancy, that is the new tenancy granted by operation of law to Mrs. Hussain on Mrs. Hussain's death. So that's how the case was being presented to His Honour Judge Hellman, and it recognised that for there to be a new tenancy, there had to have been a surrender of the old tenancy. What His Honour Judge Hellman found at paragraph 54 is that sequence of events. So that's over the page, my lord, my lady, at page 128, again the paragraph at the bottom of the page. In the present case, I am satisfied as follows. First, the first defendant unequivocally relinquished possession. He moved out of the property, he requested alternative accommodation for the claimant, and he accepted a new social housing tenancy. Recall he did that in June 2012, and if in this case the surrender and the new tenancy take effect after the 1st of April 2012, the appellant has no right to succeed to the tenancy.
2011, I think, aren't we?
2011, I apologise, my lord. So no, the Localism Act came in on the 1st of April 2012. I think it changed the rules from the 1st of April 2012.
The new tenancy was 2012.
If the new tenancy
the request for
Yeah.
accommodation,
yeah,
well, there were two of them. On
yeah,
the
are in May 20.
11th and 23rd of May 2011.
They are, yeah. But the judge there is relying, it seems to me, in part on the grant of him accepting a new social housing tenancy, which he accepted after the 1st of April 2012.
Do you mean the 1st of August?
No.
April? What's April got to do with it?
So after the 1st of April 2012, the 1985 Housing Act was amended by the Localism Act
Oh, I see.
to provide that only spouses or civil partners could succeed and not members of family who had been living with the deceased tenant for 12 months prior to their death, unless the tenancy agreement provided something different. So the Localism Act restricted or reduced the number of people entitled to succeed to a secure tenancy. But it only applied in relation to tenancies granted after the 1st of April 2012. So if you had a tenancy that was granted before that date, the old rules, which allowed a wider spectrum of people to succeed, would apply.
So your point here is that in order for Mr. Rahimi to succeed, he has to establish that the surrender and re-grant was complete before the 1st of April 2012.
Absolutely. I don't think I'm going to need to rely on that in response to this appeal, but it's just pertinent or relevant that one of the matters that His Honour Judge Hellman relied on as part of the unequivocal conduct of the first defendant, Mr. Kazom, in relation to the process of surrender, was that he accepted the tenancy of other premises.
Do we know when in 2012?
We do, because he says that in his judgment at paragraph 8, back on page 121.
November. No.
In or about June
June.
2012, Mr.
Yes,
Kazam. So after the 1st of April 2012. This isn't the significant point that I'm taking you to in going to His Honour Judge Hellman's judgment. I'm just showing you, my lord, my lady, how His Honour Judge Hellman approached the case and how what you're currently being presented with not only deviates from His Honour Judge Hellman's findings, it also deviated from the way in which the case was presented at first instance, or argued. I apologise. Carrying on reading paragraph 54, third line down, right at the end of the line. He notified the Housing Benefit Department of the claimant that he had left the property, the clear implication being that he would no longer be claiming housing benefit in relation to it. His failure to serve notice to quit, not surprising perhaps, as he had been excluded from the property, and the absence of evidence that he returned his keys does not negative the unequivocal nature of the above indicators. Then at paragraph 55, the next process in the sequence, I am satisfied that the council, the claimant, unequivocally accepted the first defendant's surrender. That is because they removed the first defendant from the rent account, as happened in Ealing Family Housing Association Mackenzie. I draw the reasonable inference that the claimant was also instrumental in rehousing the first defendant. He had, after all, applied to be rehoused to them. The claimant would have been most unlikely to rehouse him had they formed the view that he would remain a tenant of another social housing property in the borough. Third element in the sequence, 56, I am further satisfied that Mrs. Hussain unequivocally agreed to the termination of the joint tenancy. She did so by excluding the first defendant from the property, in respect of which there is no evidence. I accept that she excluded him from the property by asking him to leave from the near contemporaneous letter to that effect on behalf of the first defendant, to which I referred earlier in this judgment to the Westminster Homelessness Unit. There is no evidence that the exclusion was rescinded, as the first defendant never returned to the property and certainly never returned to live there.
Yeah.
It's difficult to see how Mrs. Hussain accepted the unequivocal surrender of Mr. Kazam by an event that had predated that, but that's what His Honour Judge Hellman found. So he found by excluding him, asking him to leave, which he then did, which was his unequivocal act, she accepted his unequivocal act. But there we go. So that's how His Honour Judge Hellman came to the conclusion that there had been a surrender. That mattered because His Honour Judge Hellman's position was, without the surrender, there couldn't be a new tenancy. That proposition is very clear from the judgment of Mr. Justice Morgan in Sable. Which is tab 18, my lords, my lady, in your bundle. Again, I'm going to refer to paragraph 10 and the 10 principles set out therein. But before I do that, if you turn onto paragraph 59, my lords, my lady, on page 165, which on my copy appears to be paginated sort of up on the right-hand corner somewhere. If you find page 164, 165 is the next page, but not paginated in the bottom right-hand corner. Paragraph 59, Mr. Justice Morgan said this. And in this case, the landlords were suggesting that there had been a surrender. The landlord's case on this appeal proceeds by the following steps. The first step is that the landlords granted a tenancy at will to QFS. The second step is that LDC, who are the original tenants, through its receivers, assented to the grant of that tenancy at will. It is admitted that their assent, LDC's assent, is shown by four matters. First, the receivers knew of the existence of the lease and of its terms. Secondly, the contents of the receiver's report to the creditors reflected their view that LDC was no longer liable under the lease. Thirdly, the receivers were aware that QFS was paying rent to the landlords. and believed that the liability for rent was that of QFS and not of LDC, and fourthly, the receivers knew that the lease had not been assigned to QFS. Paragraph 60, Mr. Justice Morgan says, I question the first step in the above reasoning. It is true that it was common ground before the judge and before us that if, I stress if, the lease had been surrendered by the conduct of the landlords and of QFS, would have justified the implication of the grant of a tenancy at will. Paragraph 61, where there has not been a surrender or other determination of the lease, in my judgment, it would not be right to imply the existence of a direct tenancy at will or licence from the landlords to QFS. If the lease had not been surrendered or otherwise determined, then it continues to exist. I accept that Sable concerns the situation in which the landlord allowed a third party, not the original tenant, into occupation of the premises. So QFS was not LDC, although there's some suggestion that some of the same parties were involved in QFS as in LDC, but they were companies. So QFS is clearly a separate legal entity from LDC. My submission, my lords, is that the grant of a tenancy to one of joint tenants, where there have previously been joint tenants, must follow the same principles as the grant of a tenancy to a third party.
Yeah.
So the reliance my learned friend puts on the case of Ahmed is simply wrong, because in that case Mr. Ahmed was the sole tenant and therefore could surrender the tenancy by the execution of a joint tenancy. In that case, it may be important that in fact neither of the tenancies had commenced at the date, were expressed to commence at the date on which they were executed. They were executed in advance of the date of their commencement. Mr. Ahmed, having signed the sole tenancy, went back with his mother and signed the joint tenancy before either of them had commenced. So there was no question about possession in that case, because they couldn't go into possession because the tenancy hadn't commenced.
But if you go on in Mr. Justice Morgan's judgment to paragraph 63, he's saying that the case under consideration is different from those discussed in Woodfall.
Yes.
They proceed on a basis that it can be seen there is a new letting. In such a case, where the original tenant requests that a new letting take place or otherwise unequivocally assents to it, then there is an implied surrender immediately before the new letting. And that's made because there is an inconsistency between the existence of two incompatible tenancies. So if Mr. Westgate shows that with the consent of Mr. Kazan, Westminster did grant a new tenancy to Mrs. Hussain, then a surrender must have taken place, mustn't it?
My lord, the way in which I understand the case to be being put by Mr. Westgate is that because there was a grant of a new tenancy, you must that is enough to amount to the surrender. That isn't what that paragraph says. What that paragraph says is there must be the surrender before the new tenancy.
Or does it? Where the original tenant requests that a new letting takes place or otherwise unequivocally assents to it,
yes,
then there is an implied surrender immediately before the new letting.
So the new letting.
That's what Mr. Westgate relies on.
My lord, the new letting is not sufficient of itself.
Well, if it's with the consent of Mr. Kazan, why is it not sufficient?
I'll come to whether assent is enough. In my submission, it isn't. But let's say that assent is enough.
Well, that's what Mr. Justice Morgan says.
It is what Mr. Justice Morgan says in Sable. If the new tenancy is granted with the assent of the original tenant, and if they are joint tenants, obviously with the assent of both of them, and presumably we assume Mrs. Hussain's assent, then in those circumstances, the grant of that new tenancy is the evidence of the surrender. but there has to have been unequivocal conduct indicating by the other joint tenant that they assent to the grant of the new tenancy.
Just to be clear, take that situation, you've got a joint tenancy, and the one joint tenant who no longer wants to be there
Yes.
says to the other one, look, I'm absolutely happy for you to enter into this new tenancy, so that there's authority, and that joint tenant then enters into the new tenancy with authority from the joint tenant who doesn't want to be involved anymore. You say that's not good enough.
I'm saying that's not good enough. And so your interaction with my learned friend Mr. Westgate about whether as a matter of principle it is sufficient if the joint tenant assents, I can see why in a tripartite contract where each of the parties have different interests, that might very well be the case. But here the joint tenants have a joint and several interest.
They have a joint. How do they have a several interest?
Sorry, they have a joint interest, I apologise. They stand in the same shoes in relation to the landlord. And as we've seen from the tenancy agreement, because it's a joint tenancy, the occupation by one of them is effectively sufficient to amount to occupation by both of them. And one of them, one of both each. Well, under the Housing Act 85, section 80,
Occupation by one of them is sufficient to satisfy the tenant
condition.
It doesn't mean it's occupation by both.
It isn't. No. Sorry. If an absent tenant remains, the tenancy condition. How can I put this? I apologise. Possession is not surrendered up to the landlord, and possession is not given up if one of the joint tenants leaves the premises. Yes. That's the point. So where that is the case, in my submission, in order for there to be a surrender by operation of law, where occupation by one of joint tenants is sufficient to amount to the preservation of the possession of the premises vis-à-vis the landlord, it is necessary for both of them to do an unequivocal act that indicates that they're giving up possession. And if we go to Wallace and Hands, so perhaps I ought to start this by saying the way in which I was going to approach this was not respond to the four grounds, because in my submission, really, this case turns on effectively three issues. The first issue is whether the grant of the new tenancy agreement does not require an unequivocal act inconsistent with the continuation of the original tenancy agreement.
Requires unequivocal act other than the grant.
Other than the grant, yeah. And we say it does.
And just so I understand that, do you say an unequivocal act from each of two joint tenants other than the grant?
Yes.
So,
one of them could perform the unequivocal act, but the other one must indicate to the landlord that they are assenting to that act. It's not enough that they assent to it. Their assent must be made clear to the landlord.
So just relating that to what we're concerned with here, suppose for the sake of argument that there had been a written new tenancy agreement between Westminster and Mrs. Hussain.
Yes.
That would have been an unequivocal act by her, presumably.
Yes.
But you say that would not have been good enough of itself. There would have needed to have been an unequivocal act from Mr. Kazam vis-à-vis Westminster assenting to the grant of that tenancy.
From which his assent could be inferred, yes.
Well, in this case, could it be inferred from the solicitor's letter that was sent on his behalf?
You can take cumulatively all of the things that he did. So if you take his leaving possession and his letters to the local authority about housing benefit, you might say that those are sufficient to amount to his unequivocal indication that he regards the tenancy as having come to an end.
And just proceeding that for a moment.
So, sorry, so the unequivocal act doesn't have to be the same unequivocal act. It could be different unequivocal acts.
And I think when you were explaining that a moment ago, you were saying, you referred to unequivocal conduct indicating, I'm going to get this wrong, being content to the tenancy being at an end.
Yes.
Is that the same or different as unequivocal assent to the new tenancy?
That's different to unequivocal consent to the new tenancy because where you have the grant to a third party, it isn't enough that the third party and the landlord have agreed that the third party should have a new tenancy.
So just relating it back again, suppose Westminster had granted Mrs. Hussain a new written tenancy.
Yes.
It would have been good enough, would it, for that to take effect, that Mr. Kazam had done something unequivocally indicating that he didn't want to be a tenant anymore.
Yes.
Yeah.
So that's really elided the first two principles which I was going to make submission about. The third.
Sorry, what's the second? The second principle is what?
Well, the first principle, the first issue is the grant of a new
tenancy requires an unequivocal act other than the grant itself in order to support the surrender. What's the second point?
The second point is there the grant of a tenancy agreement, a new tenancy agreement of the same premises, whether to the existing tenant or to a third party, a different type of surrender by operation of law or require different principles to a going out of possession case, a simple going out of possession case. And our answer to that is they must follow the same principles. And then the third issue is timing and cumulative acts. So if I could deal with whether or not the grant of a tenancy of premises of which there is an existing tenancy is a different type or requires a different approach to the general approach to surrender by operation of law. My submission is that no, it requires the same approach, and that is clear from Sable, which is a purported grant of a new tenancy case. And where Mr. Justice Morgan deals with the principles, he doesn't say a surrender where there's a grant of a new tenancy is a different type of case. So if you look at those principles at page 158 to 159 of the authorities bundle at tab 18,
Isn't his point 9 against
Yes.
you? Where the tenant requests the landlord to let the property to a third party and the landlord does so, the lease is surrendered at the time of the new letting. It's essential the new letting is effected with the consent of the original tenants. If the original tenant does not consent, there's no surrender, but his consent may be inferred.
My lord, yes, but in my submission it goes further than that, because you'll see from the earlier authorities that something more than the assent is required. So a going out of possession, or something that is akin to what we was referred to as the notoriety, in the Lyon and Reed case. Excuse me a moment. So, if you go to, and you've taken me there, my Lord, Lord Lewison, page 166 in the Authorities Bundle, paragraph 63.
Yeah.
You'll see that the word that's added from the principle is unequivocally assents to it. The position in the present case is very different from the cases discussed in Woodfall at paras 7.30 and 7.31. Those cases proceeding on the basis that can clearly be seen there is a new letting of the premises. In such a case where the original tenant requests the new letting takes place, or otherwise unequivocally assents to it, then there is an implied surrender immediately before the new letting. So that comes back.
I thought the submission you were just making was that assent, however unequivocal, is not enough. There needs to be something akin to the giving up of possession.
So my lord, that's taken from Wallace and Hands, which is in the supplemental bundle that was handed up to you.
Anyway, that is your submission, is it? Unequivocal assent is not enough. If the tenant either requests the grant of the new if the original tenant requests the grant of a new lease and the landlord does it, or the tenant unequivocally assents to the grant of a new lease, that is not enough. Is that your point?
My lord, that is necessary but not sufficient. So when Mr. Justice Morgan says, so you're dealing in a case here where what Mr. Justice Morgan found was that on the facts, it couldn't be found that the grant of the tenancy at will had been assented to.
Yes.
So he didn't need to go further than that. When we're dealing with surrender by operation of law, what we're in fact giving is the parties a concession from compliance with the formality requirements. So it's being said, there are formality requirements in relation to the determination of a lease, and that should be done by deed. But the courts will infer, the law will infer, that there has been a surrender where the conduct of the parties forces that conclusion.
Yeah.
So it's not surprising that a high bar is set, because the statute of frauds previously and the Law of Property Act now requires the determination of a lease to be by deed. So it's only in exceptional circumstances that the courts should infer that there has been a surrender.
I'm probably getting your skeleton. Can I just understand the significance of this argument?
Yes.
I think you accepted a while ago that but now maybe you didn't. Is it the case that you accept that if there is a new tenancy purportedly granted by Westminster to Mrs. Hussain, there is then an implied surrender and the new tenancy takes effect if Mr. Kazam has done something unequivocally indicating that he doesn't want to be a tenant
So my submission is that the grant of a new tenancy to Miss Hussain only takes effect if Mr. Kazam has indicated and confirmed that he assents to that grant,
Now,
because the joint tenancy continues.
I'm afraid I'd understood you earlier saying that it was good enough that Mr. Kazam had done something unequivocally indicating that he didn't want to be a tenant anymore.
That he assents to that, yes.
That he didn't want to be a tenant anymore.
Yes.
Now here the judge found that Mr. Kazam unequivocally relinquished possession and so on, I think. That sounds rather as though he accepts that Mr. Kazam unequivocally indicated he didn't want to be a tenant anymore.
Yes.
In which case, why does it matter whether there's a requirement for unequivocality?
Well, there has to be, sorry, because it's a joint tenancy and because the joint tenants stand both as tenant, they also, Miss Hussain also was required to indicate her consent to the determination of the joint tenancy.
But that takes us back to ground 4. Was there, purportedly, a grant by Westminster to Mrs. Hussain of a new tenancy? The rest of it doesn't seem to matter.
My lord, our position is that the new tenancy cannot have been granted until the old tenancy was determined.
Yeah.
And that required some unequivocal indication from Mrs. Hussain that she also agreed to the determination of the joint tenancy. So if I could take you to Wallace and Hands, which is tab 2 of the additional bundle of authorities, page 81 in the top right-hand corner, page 23 in the bottom right-hand corner. This is a judgment of Mr. Justice Chitty. And this was a case which concerned grants of leases of mining leases of collieries, one granted in 1884 and then the subsequent one granted in 1887 to third parties. In these circumstances, so about a quarter of the way down the page, a paragraph, or not a paragraph, sorry, a sentence starts. In these circumstances, it's intended for the plaintiff as a proposition of law that the grant of a new lease in possession with the oral assent of a person in possession under a prior subsisting lease operates as a surrender in law of the prior lease. So that's what was being argued on behalf of the party that was seeking to say that the 1884 lease had been surrendered. The claimant was the landlord and was seeking to get some rent arrears from the defendant. If you turn over the page, or perhaps I'll start at the bottom of that page, you'll see Mr. Justice Chitty found that there was a controversy or inconsistency between Thomas and Cook, which you have in your principal bundle of agreed authorities, and Lyon and Reed. So the question again raises a controversy which subsisted at one time between the courts of King's Bench and Exchequer, illustrated by Thomas and Cook and Lyon and Reed, and discussed at length in Smith's leading cases. But it appears to me the controversy was, so far as concerns the question before me, set at rest in the judgment of the Court of Exchequer in Davidson and Ghent. In Thomas and Cook, there was in fact a change of possession, the old tenant Cook having gone out of possession when the plaintiff accepted Perks as his tenant. Perks, in fact, was Cook's subtenant. In his judgment in Davidson and Ghent, Chief Baron Pollock states the law thus: 1. It must therefore be taken to be established that where a lessee assents to a lease being granted to another and gives up his own possession to the new lessee, that is a surrender by operation of law. This statement appears to me not to be qualified by any subsequent expressions in the same judgment. It substantially reconciles Thomas and Cook with the principles enunciated by Baron Park in Lyon and Reed. so far as relates to leases in possession. So what is then required, or how do we approach that question? Mr. Justice Chitty says it's not perhaps of any great practical importance in which of the two following ways the proposition of law is stated. There is no surrender by operation of law unless the old tenant gives up possession to the new tenant at or about the time of the grant of the new lease to which he assents, or two, the change of possession is a necessary part of the consent. I prefer, however, the first as being the more correct form. And this is the important part, my lords, my lady. To hold that mere oral assent to the new lease operates as a surrender in law would be a most dangerous doctrine. So that is why we need some evidence of Mrs. Hussein's concurrence or agreement with Mr. Hussein's offer of the surrender of the joint tenancy.
What form could that take?
A letter from her saying Mr. Hussein has left. I would I mean, the point about this is all that happens in this case. What isn't enough is her remaining in possession of the premises, because she was entitled to do that under the joint tenancy anyway.
But if there were a change of possession from joint possession to sole possession, would that be enough?
In this case, no, because as is said, expressly said at the beginning of the tenancy agreement, it's sufficient if one of the joint tenants occupies the tenancy, but you will remain jointly liable under the rent. So in my submission, that isn't enough. And how is one to identify that?
But in this case, Westminster actually enabled one of the joint tenants to avoid his liability under the tenancy agreement.
They did.
Because they indicate that he's no longer to be pursued for the rent.
They did. But
So how could they do that if they hadn't accepted the cessation of the joint tenancy? Because otherwise they'd be implying conditions within a joint tenancy, amending that which had been signed by both joint tenants.
well, as my learned friend has said, it's the intentions of the party is not what matters here. It's what we can objectively identify
That's why I'm asking
as
you
their
about
conduct.
what Westminster did, because we can objectively identify that.
That was not communicated to Mrs. Hussein. So when it said, well, she must be assumed to have accepted that she became the sole tenant, what we do know is that when she made the application for her grandson to come and live with her, the tenancy she produced on her witness statement is the joint tenancy. So after 2011, at the time at which she was supporting her grandson's application to remain in the UK, to come and live with her, she did a witness statement.
Yes, I understand. Is it possible for Westminster Council, the landlord, to unilaterally alter the terms of the joint tenancy
No.
in order to remove the liability of Mr. Kazim to pay rent?
No.
No. And therefore, if Mrs. Hussein, following the departure of her husband, had not paid rent, would it have been possible for Westminster Council to pursue her husband for the rent?
Yes.
On what basis, given the internal documents?
Because he was a signatory to the joint tenancy. The fact that they didn't, in my submission, is neither here nor there. He was the joint tenant and he remained the joint tenant. The fact that he gets a tenancy of other premises doesn't mean that he can't also be the joint tenant of these premises.
Yes, but there's an inference to be drawn there, isn't there? That Mr. Westgate asks us to draw, which is that he's hardly likely to have been given a second residence in social housing if he had a residence that he could return to.
In circumstance,
Sorry.
in my submission, that is an inference too far, because we don't know the circumstances in which he was rehoused. It's right that he applied to the local authority, and the judge drew the inference that the local authority assisted him in finding new accommodation. But it isn't the case that in order to be homeless and not homeless intentionally, if you have another tenancy, you can be one of joint tenants excluded from a premises can still be somebody who can go on a housing register and be offered housing by a local authority, and can be somebody to whom a local authority owes a homelessness duty. In general, what happens is that it's a woman who leaves the premises where they're let as a joint tenancy, and the council, a local authority, will in general ask her to make an application to exclude the man if they're a heterosexual couple, and in general it's a woman who will have, I'm sorry about all these generalisations, a woman who has care of the children.
Or they ask her to serve notice to quit.
Or they ask her to serve notice to quit. Yeah. But that doesn't mean that Mr. Kazam could not be rehoused because he had a joint tenancy of other premises. So that inference goes too far.
All right, but they never did pursue Mr. Kazam again, did they, for the rent, even after Mrs. Hussein's death?
No.
Even though he would have remained on your case a joint tenant?
They didn't. That's absolutely right. But if she was paying the rent, they would have had
her death.
Absolutely. But whilst she was paying the rent, they had no interest in pursuing him because she was paying the rent.
But what you have got is the judge's finding at the trial judge's finding at paragraph 57, when he says that he has no evidence that Mrs. Hussein agreed to assume sole responsibility once.
Absolutely. Yeah. And in my submission, that's supported by the fact that when she produced a tenancy agreement indicating what her right in the property was, she produced the joint tenancy. The inferences that you're asked to draw about there having been some agreement with her that the tenancy changed from joint to sole, in my submission, must fall down, because if there had been some express agreement with her, as asked by my Lord Justice Newey, then a new tenancy agreement could have been signed. So it seems to me that inference is not only one that shouldn't be drawn, it's one that seems unlikely in the circumstances, given that if there had been an express agreement and meeting with her, the simple thing would have been to sign a new tenancy agreement. So coming back, my lord, to the second question, is grant of a tenancy a different or a subset of surrender by operation of law? In my submission, the answer to that appears in Sable, where the principles set out by Mr. Justice Morgan don't distinguish between surrender by giving up of possession and surrender by the grant of a new tenancy, but give as an example of surrender the grants of new tenancies. So if you go to paragraph 6, the 6th of Mr. Justice Morgan's principles, my lord, my lady, that's on page 159 in the authorities bundle, you'll see Mr. Justice Morgan says the conduct of the parties, and that's important, my lords, he refers to both parties, must unequivocally amount to an acceptance that the tenancy has ended. There must be either a relinquishment of possession and its acceptance by the landlord, or other conduct consistent only with the cessor of the tenancy. One, where there's a re-grant of a tenancy to the same tenant, that of course doesn't require anything else, because if the new tenancy is a tenancy in occupation during the currency of the old tenancy, the landlord wouldn't be able to grant the new tenancy unless the old tenancy came to an end. And so, in effect, the grant of a new tenancy has all of the ingredients necessary for the finding of surrender by operation of law.
Can I just see how this might fit together? So you say where you have a new tenancy granted to the original tenant, that has all the necessary ingredients, that of itself constitutes the requisite inconsistency with the old arrangement that you need for a surrender.
My lord, yes.
Now we assume that there was a joint tenancy, and vis-a-vis one of those tenants, that happens. So at that stage we have, as regards that tenant, all that's needed, presumably.
Yes.
So the question then is, what is required from the other joint tenant?
Yes.
And Mr. Westgate was saying, well, look at Leek and Morelands and other cases. They show that it's enough to have authority, assent, concurrence, possibly acquiescence. Why isn't that right?
That isn't right because the surrender process as an estoppel requires a representation. We've called it an offer in our skeleton argument, and I think that's the right position to say, to use, and that offer must come from the tenant, and if the tenants are joint tenants, it must come from both of them.
But let's take the case of pure authority. As a matter of ordinary law of agency, if one person does something with authority from the other one,
yes,
that can work for estoppel purposes.
It can, but in this case, what has to happen is, if there are joint tenants and only one of them gives up possession, but does so with the authority of the other, the landlord hasn't had possession given back to them. And so, as we've seen,
Why not?
Because the other joint tenant who's entitled to remain in possession under the joint tenancy is still in possession.
But he's just consented, on your example, to the giving up possession to the landlord.
But it requires more than that, as we've seen from Wallace and Hans. It requires them to give up possession. The fact that they've assented to giving up possession isn't enough.
Right.
They have to actually physically give up possession.
If there's a single tenant who takes a new lease from the landlord,
My lord, yes.
I think in answer to my Lord Justice Newey, you said that's got all the ingredients that you need. So there is no change of possession in that case. So a change of possession is not necessarily an essential ingredient of a surrender by operation of law. Is that right?
In the case of the grant of a tenancy to a new tenant. Sorry, to the same tenant, I apologise. And that's because of the presumption that those two parties cannot have entered into the new tenancy unless the tenant had given up possession. Now, the one case in my submission that I need to deal with in relation to this is Macur and Boyce, where Mr. Boyce remained in possession and there was a grant of a new tenancy to a third party.
So just to be clear, in the joint tenancy example, we assume for the sake of argument that there is an express grant of new tenancy to joint tenant A in circumstances where joint tenant B authorises that, expressly authorises it, and has left with no intention of returning.
Sorry, B has left.
B has left with no intention.
And A has left or not?
No. A is still there and is granted the new tenancy. So there's a
the facts in this case, effectively, or we don't know because we don't know what authority flowed between.
Let's leave this case out of it for one moment. So,
My lord, yes.
So we have a situation where you have two joint tenants, A and B. The landlord grants a new tenancy to A in circumstances where B has expressly authorised that and has left the property forever. Will that work as a surrender?
The new tenancy is granted to the remaining tenant.
Yep.
And the departing tenant has authorised
the tenant who's now getting the new tenancy to enter into the new tenancy.
If the departing tenant has indicated to the landlord.
No, leave the landlord out.
Okay.
We're just assuming that the departing tenant has given authority to the remaining tenant to enter into the new agreement.
No, that's not sufficient.
Because
the landlord hasn't been informed of the consent of the departing tenant.
So you say there is a requirement that the landlord. Actually, I'm probably yes. Can I add on one further thing then?
Yes.
I'm getting closer to the facts of this case. So, the departing tenant has authorised the remaining tenant to enter into the new agreement and has made it clear to the landlord that he doesn't want to be there anymore, that he doesn't want the tenancy anymore.
Yeah, that's sufficient.
Yes, I see.
But because in my submission, because it's based on an estoppel, and because the joint tenants stand in the same, both have the right to possession, the unequivocal act has to be one that the landlord understands both of them concurring in. They don't have to do the same act, but it has to be coincident. It has to be sufficiently coincidental for the landlord to understand that the representation that is being made is that they no longer want that tenancy to continue.
And that proposition is consistent, is it, with Leek and Morelands and the other cases, which Mr. Westgate says show you it's good enough to have assent concurrence.
The reason why they say that is because that in those cases the assent wasn't. There wasn't even assent. So the courts didn't have to go further than that. So when Mr. Westgate relies on McGrady, for example, that was in fact a case about a notice to quit given by one of joint tenants. So the discussion of surrender by joint tenants was obiter. And it was drawing the distinction between when joint tenants can surrender a tenancy, what's required, and when one of them can serve a notice to quit. And in McGrady, the court says, well, there has to be assent of all of them. Well, that's absolutely right. There does have to be the assent, but that isn't sufficient. But that was all that was necessary to say in those cases. The one case in which there is not a giving up of possession in my submission is Metcalfe and Boyce. That's the case involving the police officer who originally occupied the same house, the original house, as a tenant of the police authority.
No, I think it was a tenant from Sir George Wills.
He was, absolutely, sorry, you're absolutely right. So, yeah, no. A third part, I apologise, my lord. The original tenancy was from a third party, and what happened was that the police authority decided that in future the the tenant would be the chief constable of the police authority, and that each of the police officers occupying them would be occupying them as service occupants, on a service occupancy basis. And what happened in that case is that Mr. Boyce, having previously paid the rent directly, after the change in status, which was explained to him, presumably because he changed his behaviour, would take the rent demands which were addressed after that to the police authority and to the relevant police office, where he was given the money to pay the rent, and the demands were made to the police. The demands were not made to him, but they were made to the police authority. In those circumstances, he did remain in occupation. But my submission is it's clear from that case that he gave up his possession as a tenant.
Well, he assented to an arrangement by which the chief constable had possession.
Yes, and he was
means of a service occupier.
My lord, yes, you put it.
Because the service occupier does not possess in his own right.
That's right.
He is a representative of his employer.
So whilst he didn't move out and give up possession, what he did was recognise that he was occupying on behalf of somebody else.
I don't like to quibble over much, but he did give up possession by accepting from the chief constable a status which did not give him possession. I mean, there's room for argument about whether he gave up possession to the landlord as opposed to the chief constable, but once this new arrangement came into effect, he was no longer in possession.
No, he wasn't in possession as a tenant. He remained in occupation.
Remained in occupation, certainly.
Accept that.
But there is a difference between the two.
Yes. So, my lord, those are my submissions on those first two propositions. In relation to the timing aspect, my learned friend relies on Sharma and Vyas as authority for the proposition that you can look at a long course of conduct. In my submission, the issue in Sharma and Vyas was, had the local authority accepted the surrender before it issued the proceedings? So that's clear from, it's divider 12, my lords, my lady. Head note, these are the housing law reports, so the head notes tend to go on for a few pages. But on page 68, you'll see held dismissing the appeal. Number one, the court is entitled to look at the whole of the conduct of the landlord prior to the issue of proceedings. If by the time of the issue of proceedings it is quite plain that a landlord has accepted by his conduct or shown by his conduct that a tenancy no longer existed, then the conditions giving rise to a surrender by operation of law are established. Why did that matter? Well, because the landlord was relying upon a notice to quit, and so if they'd accepted the surrender before they served the notice to quit wouldn't have been valid because there'd have been a new tenancy. So in my submission, they don't say, this isn't authority for the proposition that you can look at the conduct ad infinitum. It's authority for the proposition that there may be circumstances in which you can look at conduct over a longer period of time. In this case, the conduct really doesn't change. In the current case, the conduct doesn't change. What is said is the local authority changed an internal record, and thereafter Mrs. Hussain paid the rent, which she would have had to have paid whether she was a joint tenant or a sole tenant. So that conduct, in my submission, can't be used cumulatively to say she had a tenancy, because at that point you end up saying, well, at what point did she acquire her tenancy? Was it after paying the rent on her own account for a year? Was it immediately? If it was immediately, then you can't look at the cumulative behaviour because at some point the tenancy has to arise. And the new tenancy can only arise if the old one's been surrendered.
I mean, it used to be the case that where tenants were on housing benefit, the benefit got paid direct to the landlord, but I don't think that's the case anymore.
It happens in some cases and not in others. I think people can ask for direct payments. The idea with universal credit was that it would encourage people to behave as if they had a wage, I think, and so they get the universal credit for themselves and then are meant to prioritise their...
We know that Mr. Kazan notified the housing benefit unit.
He did.
So presumably that he or somebody was getting housing benefit.
Yes.
We don't know, do we, by what means Mrs. Hussein
Paid the rent. We don't.
paid the rent?
Well, on page 26 of the supplementary bundle, there is a reference in that little table to HB overpayment, which seems to suggest housing benefit overpayment.
It does.
So that would have gone directly to the local authority if it's in their record, wouldn't it?
It would, but that's dated. That appears to be dated the 18th of October 2020. Although, so if we look at that screen dump, my lady.
Well, I think that was the date of when Mrs. Hussein definitely was in occupation with her grandson.
Yes.
And her husband was not.
No.
So that the housing benefit, therefore, was in relation to Mrs. Hussein.
It was her claim for housing benefit. Absolutely.
Yes, but it looks as though it went directly to the local authority, for what it's worth.
It does. Yes.
Just in response to your saying that there's no evidence of whether it went directly. Or
No.
not.
Thank you.
And there was one other thing I wanted to ask about this page. What do the letters CSH stand for? CSH tenancy. Secure CSH tenancy is what the annotation says.
I'm really sorry. I don't know, my lord. And I don't have an instructing solicitor here. I apologise. I mean, it's clearly a secure tenancy if it's under the 85 Act. It's not an introductory tenancy. I don't know if it's a reference to it not being an introductory tenancy. It's a weekly periodic tenancy.
Anyway, you don't know.
No,
All right.
I apologise. Okay, so sorry, we understand it might have been sheltered accommodation. So SH might refer C community sheltered housing tenancy. I don't know.
Right.
Sorry, if I could take you to the judgment of Lord Justice Scott in Sharma and Vyas, that's on page 70. He confirms that unilateral conduct by one of the parties to a tenancy cannot of itself bring to an end the tenancy. Surrender by operation of law requires unequivocal conduct by both landlord and tenant. The landlord, it seems, was not entirely clear as to the legal effect of the conduct of Miss Vyas. So the council did three things. And then it sets out the three things that the council did. And then if I ask you to... Just need to find my notes.
Do you know what the significance of February 1989 is?
Wasn't that the date of the issue of the proceedings?
No, the proceedings were issued on September the 14th, 1989. See page 69.
Yeah, I've made a note. I apologise, my lord.
Maybe it's just that it follows the end of January. You see what I mean? In the sense that Lord Justice Scott has referred to something as at the end of January in the previous paragraph.
Well, the notice
That's
to
the
quit
notice
was
to
sent,
quit,
I think.
which required possession on the 16th of January. Well, never mind.
So going up the page to the judgment of Lord Justice Stuart Smith, you'll see there's a paragraph which is one of the highlighted paragraphs. And the argument in this case was whether or not the court had to pinpoint a time. And what Lord Justice Stuart Smith says, well, Mr. Dougal submitted that it was necessary to pinpoint a time from when the surrender operated. in some cases that might be so. So it's not a case that you don't have to pinpoint a time ever. It's the case that in London Borough of Brent and Sharma and Vyas, what had to be established was that there had been a surrender before the council issued its proceedings. If there was a demand for rent, or if there was some question as to whether or not a repairing covenant had been complied with, then the court might be faced with the difficult task of deciding precisely at what moment the surrender operated. But in my judgment, in this case, that problem does not arise. It is quite plain, as it seems to me, that by the time the proceedings were issued, the landlord had unequivocally shown that the tenancy no longer existed.
So the argument for Mr. Sharma, was this the argument? The argument for Mr. Sharma was, well, you haven't served a valid notice to quit on Miss Vyas. There's been no surrender, therefore her tenancy continues, therefore you can't claim possession against me. Is that the argument?
That's the argument, yes, my lord.
So he's not saying you granted me a new tenancy.
No.
He's just saying you haven't yet terminated the old one.
Yes. Now, the reason why I submit that that is relevant in this case is because what you're being asked to do is look cumulatively at what the parties have done. But in my submission, if you accept the proposition that the grant of a tenancy to a third party, the grant of a tenancy to one of joint tenants is akin to the grant of a tenancy to a third party, and therefore the tenancy cannot be granted unless the earlier one has been surrendered. It is necessary to look at when the surrender was, because that determines when the grant of the new tenancy takes effect. And if we go back to what His Honour Judge Hellman relied on, he relied upon Mr. Kazam being granted a new tenancy. So one of the elements that he took into account in finding that Mr. Kazam had done an unequivocal act with a series of events that His Honour Judge Hellman recites at paragraph 54, I think it is, of his judgment.
Yes, but the acceptance of the new tenancy was only one factor.
It's only one factor, but if we have to analyse what His Honour Judge Hellman was finding, the fact if the surrender had happened before then, then there was no need to refer to that as one of the events.
Sorry, I don't understand that. Really at the stage of the afternoon, but in paragraph 54
Is it 54? I apologise.
of Judge Hellman's judgment, he indicates that he's satisfied on the balance of probabilities implicitly. First, the defendant unequivocally relinquished possession, and then he goes on to explain why. He moved out of the property, he requested alternative accommodation, and he accepted a new social housing tenancy.
Yes.
Now, the sequence, obviously, of the new housing tenancy was something beyond the control of Mr. Kazam. He was waiting for it.
Well, his acceptance of it wasn't beyond his control.
No, but when he was offered it was beyond his control.
Yes.
He had to wait for the local
He did.
authority to find him new accommodation.
You can't make the assumption that the local authority found him the new accommodation.
But in any event, is there anything wrong with the judge then saying, well, the fact that this did occur actually reflects back to the first time he walked out of the property that he had shared with Mrs. Hussein?
Well, if that was his finding, if he was finding that his unequivocal act was walking out and that was enough, then there was no need to list the other things that happen.
Well, no, he's merely, isn't he, just saying, and this corroborates his walk out. This wasn't just, I've had a contretemps with you and I'm going out because I want to sulk or anything like that. He was saying, I'm going. And this proves his unequivocal intention to depart.
But
But why wasn't the judge entitled to find that?
no, he was entitled to find that part of the unequivocal conduct of Mr. Kazam was accepting a tenancy of other social housing premises.
Well, he didn't limit it to that, though, Mr. Grundy.
No, he didn't. No, I accept that. But that happens, we know, after this change in the law.
But you haven't ever taken a point that if there was a surrender and re-grant, it post-stated the local...
No, we haven't. We say, in this case, there isn't a surrender and re-grant. But what we do say is, the way in which this case is now being argued, not that...
But there's no respondent's notice which says, well, even if Mr. Westgate's right, then Mr. Rahimi is still not entitled to succeed because the new tenancy granted is too late.
No, there isn't. Excuse me a moment. Sorry, my learned junior reminds me that Mr. Justice Lane found... I apologise. If I can find the judgment, I'm sorry. 5. I apologise, Martin. 68. Yeah, thank you. So, Mr. Justice Lane, at paragraph 68, which is page 60 in your core bundle, my lord, my lady, Mr. Kazam, D1 is Mr. Kazam, Mr. Kazam. His conduct can only be regarded as equivocal. He was interested in being rehoused. That is the extent of the evidence. As against this, Mrs. Hussain remained in possession. In that regard, I've already explained why the judge was wrong to seek to distinguish the Ealing case. Ground 3 accordingly succeeds. So there's a finding by Mr. Justice Lane on the appeal and on the grounds of appeal that Mr. Kazam's conduct was equivocal. And there's not an appeal here before you against that finding, because what is relied upon is the grant of the new tenancy. So, my lords, my ladies, unless I can be of any further assistance, those are really our submissions are that this appeal is misguided, is a misapprehension of what is required in order to establish a surrender. And the grant of a new tenancy to a third party is not sufficient. It's not sufficient.
I would like to understand your explanation of the amendment to housing tenancy details document.
So, my lord, unless, it's my submission in relation to that, that unless there was a communication of that precise change to Mrs. Hussein so that she was told you are now becoming a sole tenant, that really doesn't matter, because the basis of the surrender by operation of law on estoppel requires a representation. And that, in my submission, is conceded by Miss Paris that it couldn't be relied upon as part of Mrs. Hussein's conduct, which in effect is a concession that she didn't know about it. In my submission, it's almost certainly an administrative error on the basis that there was a presumption that you can assign or transfer a joint tenancy to a sole tenancy between one of two joint tenants. I don't accept what my learned friend says about section 91(3)(c not amounting to a circumstance in which somebody would be entitled to succeed. It seems to me that if you are joint tenants and on the death of one of you, the other one by survivorship becomes the sole tenant, and that is defined in the Act as being a succession, in my submission that it's at least arguable that that joint tenants can assign the tenancy to one of them. Because if that was capable of happening before the joint tenant's death, then if that happened on the other tenant's death, then in my submission that could happen before their death. But I don't think I need to establish that is right, and I accept that it's arguable that it might not be right. Okay. It is absolutely the case that a person to whom a tenancy is assigned by a court order in matrimonial proceedings is defined as a successor, but that has to be done by a court order. My submission is that I suspect that the people at the local authority didn't understand that. But as my learned friend has said, their intention is irrelevant. What we're looking for is sufficiently clear and objective conduct from which the court can infer the surrender.
Can I just try to understand one thing? Mr. Westgate says it was implicit in Judge Hellman's judgment that there was a grant of a new tenancy. Do you accept that?
Yes.
Mr. Westgate says there was evidence such that the judge was entitled to arrive at that conclusion. Do you accept that?
No.
That's not really something you
argued about. No. And that's because of the way in which His Honour Judge Hellman came to his decision. So what His Honour Judge Hellman found was that the original joint tenancy had been surrendered. We've then got Mrs. Hussein in occupation paying a rent. And I accept everything that my learned friend says about those circumstances where the joint tenancy has been surrendered.
So your case depends entirely on your other submissions about the need for a prior surrender.
Yes.
You're not independently challenging the proposition that there was evidence from which that apart one could infer a new tenancy.
Absolutely.
Just to pick you up on one point, which I don't think actually matters. If the tenancy had been transferred by a court order under the Matrimonial Causes Act from the joint tenants to Mrs. Hussein,
that
she would be a successor.
Yeah, that would have counted as the single succession.
No,
and so Mr. Rahimi would not then be entitled.
Why? Look at section 88.
Yes.
88(1)(d).
Sorry, I've just lost my bundle of authorities for a moment. Apologise.
Unless I've completely misunderstood this. The tenant is 88(1). The tenant is himself a successor if, when you go down to D, he became the tenant on the tenancy being assigned to him, but subject to sections 2 to 3. In 2, tenant to whom the tenancy was assigned in pursuance of order under section 24 is a successor only if the other party to the marriage was a successor.
My lord, yes.
So she wouldn't have been.
No, she wouldn't. No, you're absolutely right, and I apologise about that.
So if there had been some sort of estoppel which barred the parties from denying that such an order had been made, Mr. Rahimi would be entitled.
He would be entitled to succeed, yes. But if, under 88(1)(b), if she was a joint tenant and has become the sole tenant,
Yeah.
then that would count as a
Yes.
succession.
Or irrespective of subsection 88(1), I suppose, yes, I see. So you say what, even if there was an order under section 24 requiring joint tenants to assign to one of them, that would be a successor. That would be a succession, not because of 88(1)(d), but because of 88(1)(b).
No, I don't say that. I say if that clearly expressly takes it outside of 88(2) is a peculiar case.
Yeah.
Yeah, if there, I mean, I understand the policy in it, which would be that where there's been a matrimonial breakdown, the person who gets the tenancy should be entitled to have a successor. They might remarry, they might have a child who lives with them. So I don't say that 88(1)(b) trumps, because they were originally joint tenants, they should become a sole tenant, because that would always, in effect, that would always be the case.
Yes. Right, thank you very much. Yes, Mr. Westgate, do you wish to...
Again, not that it matters. The construction of 88(1) that we've just been looking at does appear to be that the conditions in paragraph 88(1)(a) to E are mutually exclusive. So
Yeah.
they're mutually exclusive.
Right.
So you can't be someone who's have become the sole tenant and be in the same case. At the conclusion of his submissions, Mr. Grundy summarises it by saying that the thrust of his submissions and why he says we must be wrong is that the grant of a tenancy in a third-party case isn't enough. And of course we agree, because we agree that there must be assent. And we agree that the authorities appear to show that there has to be a change of possession, but we say that both of those really don't get anywhere in this case, because there is a change of possession here, by analogy with Metcalfe and Boyce and Ahmed, and Mr. Kassam's assent can clearly be inferred from his actions, whether they're equivocal or not, in the sense of demonstrating giving up possession. What they don't do, or rather what they clearly do, is indicate a lack of interest in the property, which is something from which it's proper to infer that he consented to the grant of the tenancy to Mrs. Hussain.
So you accept, you say that a change of possession is necessary. I suppose what you say is that a change from joint possession to sole possession is a change.
No, exactly. It's the mirror image of Ahmed. In Ahmed, a sole tenant went to a joint tenancy, and there was therefore a change of possession. That was the answer to the point I made, that there hadn't been a change of possession, because Mr. Ahmed hadn't physically gone out of possession, but he had given up his possession as a sole tenant in favour of being a joint tenant, and it works exactly the same the other way around. Mr. Grundy was also asked again towards the end of his submissions about the change in tenancy details form, and he appeared to say that that couldn't be, what wasn't material here, because in the absence of it becoming known to Mrs. Hussein, that they were relying on, there couldn't be any estoppel argument. But that we suggest is the wrong analysis, because the relevance we place on it is not in relation to whether it's evidence of some independent, unequivocal act on the part of Mrs. Hussein. It goes to whether or not the court should infer a tenancy. So it's a wrong classification. But he went on to say that his explanation of it was it must be an administrative error, which is impossible, we suggest, to read, to gather from the language of the document itself, in that it's signed by two members of the council's staff. It's clear what it's intending to do. It refers to removing Mr. Kazam from the rent account, and that's exactly what happens. So it's hard to see that it's some document that just exists there as some mistake. But in addition to that, and my Lord, I'm conscious that I'm about to refer to a document that hasn't been referred to before. What the court has is documents from extracted from. Do we have all the appeal? But the court doesn't have all the documents that were before His Honour Judge Hellman. That's clear because, as my Lord pointed out in argument, there was a statement that is quoted from His Honour's judgment, which isn't before the court, and part of the explanation of that is that the court is only concerned with the joint tenancy issue rather than the residence issue, which is one of the points before.
Sorry, what was before the judge which we haven't got?
Well, one of the points was that my Lord referred to a statement that His Honour Judge Hellman describes, and I think there were fraud checks. That were,
the statement from the daughter, yes.
That's right. And my Lord, one of the I've been shown this afternoon in the submissions a document from the trial bundle, which hasn't, I'm afraid, made its way to the court, but it's dated the 5th of February, and it's described as a tenancy check, and it's it refers to the tenancy being a sole tenancy, and Mrs. Hussein appears to sign it, and Mr. Kazam's name is crossed out. So that appears.
What is a tenancy check? What does that mean?
Well, it seems that it may be part of the fraud check that took place.
What, to see if somebody's entitled to housing benefit?
Well, or to see who's living there. There are, I think.
We're not really doing this, are you? We're just producing documents that we haven't.
Well, it's in response to a submission that one document must be an administrative error.
Sorry, my learned friend hasn't given me any notice.
No, I'm very conscious of this, and I'm diffident about.
You don't seem to be.
Well, I don't think we can really place any weight on a document which A, we haven't seen, B, hasn't been referred to, and C, only emerges in the course of your reply.
Well, I see the force of all those points, and it's I'm not.
And isn't referred to by the trial judge.
No, it's not. But I suspect that it's dated 2015, and I suspect that Mr. Grundy would say it comes far too late in the history anyway. But it was really as part of the submission that it simply can't be gathered from what we have from the tenancy amendment form that's some kind of administrative error. Yeah. But I appreciate that it's too late for me to raise this point. So those are the points that Mr. Grundy concluded on. Just to pick up on some of the other arguments that he raised, he took you to various points about the way in which the case was put below, and in particular in the before His Honour Judge Hellman. Lord, it's not clear to me how far that point goes and how far Mr. Grundy is saying that it's simply not open to run the points that we're running now. But when one goes to the arguments that were presented rather than the judgment of His Honour Judge Hellman, if I can ask you to look at the supplementary bundle, the transcript shows that it, if I can ask you to go to the supplemental bundle, page 75. You have Ms. Paris, this is at lines 5 to 7, saying that Ms. Hussain agreed to end the tenancy as it was, which was a joint tenancy. Then with the agreement of the council, a new tenancy arose between herself and the council's sole tenant. So she's clearly putting the case as the grant of a tenancy there. And she then, there's then a point that the judge raises at 13 and 14, saying so it's either a joint tenancy or, as the claimants say, there was a surrender and regrant. So, and Ms. Paris says precisely the same point is made by Mr. Crean. So there's an acceptance that it's a binary choice. But then if one goes down to 78, line 33, you've got, in regarding the events of 2011 to include, I'm repeating myself, the conduct of Mr. Kazam, the implied conduct of Mrs. Hussain, though I accept there's limited evidence of her conduct, certainly the conduct of the council. The only realistic assumption is that can be reached is they accepted the state of affairs as it was. They accepted the tenancy, the joint tenancy, couldn't continue in its current form, and it had to continue in a separate form as a sole tenancy. There's no way in law for that to have happened, unless it was a surrender by operation of law and a regrant of the tenancy. Now although I accept it, it certainly doesn't cover the range of arguments that this court has heard, is a clear articulation of the point that what is happening here is the grant of a new tenancy, and that's the focus that ought to be the subject of the court's attention. And what one also finds at page 108, and this is in Ms. Paris's reply, that the judge invited Ms. Paris to deal with Mackenzie, and she said at line 16, my point with regard to Mackenzie is that in this case, it's one occupier wanting to cease the tenancy, whereas one would like to stay and they're in opposition to each other because one's trying to end the tenancy altogether. In this case, it was both Ms. Hussain's intention and Mr. Kassam's intention to end the tenancy. Mrs. Hussain's intention was on the assumption new tenancy would be granted to her. So again, it's being put on the basis it's all about the grant of the tenancy, rather than the point being put at it's characterised by Mr. Grundy. So the new tenancy point was, we suggest, fairly put before His Honour Judge Hellman, and of course the point that arises here is on appeal from Mr. Justice Lane, and there the point was clearly put, because it was raised in the skeleton argument put in on behalf of Mr. Rahimi. So, Lord, it's not, we suggest, it's the skeleton, if I can take you to the skeleton argument, I'm asked to refer to it. It's in the core bundle at page 91 is, I think, where it starts. And it's really in response to ground 4. So if one goes down to page 106.
106.
106. And the council submissions on ground 4, and ground 4 was that the judge was wrong to find that Mr. Kazam's conduct amounted to giving up possession. And the councils conflate surrender and regrant and giving up possession, and then the question is whether there's some act which is inconsistent,
So it's paragraph 48.
Exactly. Well, it's the end of 47, which is in substance our submission here. In the case of a surrender and regrant, the law implies surrender because otherwise new tenancy couldn't be validly granted. And that was advanced in its defence. I won't take it as defence. And then it's 48. Again, the point was before, Mr. Justice, which we said makes it open to us to raise these points here. So far as the additional elements that Mr. Grundy says are required, in the end, what he seemed to be coming down to say was that it's that it is sufficient in the case of a grant to one joint tenant for the other joint tenants to assent to it. He says the assent's got to be unequivocal, and you've got my submissions on that. So far as the notice to the landlord, which he said was another requirement, that is inconsistent with authority, and it's not, we suggest, a sufficient answer to cases like League to say, well, the court didn't need to go that far, because it was an obvious answer in League. If notice was needed, there was no evidence of notice being given there. And also, the argument from principle can't succeed, because although the doctrine is based on estoppel, again, the estoppel arises because of the grant of the tenancy, that being the inconsistent act.
Yeah.
And the assent isn't part of the estoppel. And even if it is, it's just because the doctrine is based on estoppel doesn't mean that one has to replicate all the requirements of the modern reliance-based estoppels when one is analysing surrender by operation of law, because it's never operated in that way, and to do so is to ignore the historical development and why estoppel is said to be the foundation. And what the older cases seem to talk about is a different kind of estoppel. And as I've said in my submissions, the cases haven't yet worked through what the relationship is between those old estoppels in place, notorious acts, and modern estoppels. And so one can't say that because it's based
modern
on
estoppel has a very large dose of equity
no, indeed.
put into it, and this form of estoppel was developed by the common law.
Absolutely. And it may be, and this isn't probably the case to do it, that at some point the broad statements about it all being about estoppel and therefore certain consequences follow may need to be looked at, and it may be that the estoppel arguments stand on their own feet rather than being shoehorned into surrender. But all of that is not necessary to decide in this case. But the point I make is that it's a fallacy to say that because it's based on estoppel, all the ingredients of the modern estoppel have to be there. The only other points I wanted to deal with were yes, this probably goes to the point about whether a tenancy can be inferred and what should be made of the fact that when she wrote a statement in support of her grandson's immigration claim, she attached the 2005 tenancy. It's not something that is on a Judge Hellman placed much reliance on. And it's not something we suggest.
Well, you may have been wrong about that.
Well,
I mean, what in the Vyas case,
yes,
both judges made it quite clear that you look at the whole course of conduct.
Yes.
Now, they said that in relation to the landlord, but it must be equally true
of course,
of the tenant.
yes. We accept you look at everything, and I'd be contradicting myself if I said that you shouldn't look at everything in isolation. You shouldn't look for something in isolation, but then when there's something you don't like in isolation, you should ignore it. And so of course all these things have to be looked at in the round. But the judge was, we suggest, right not to place any reliance on it. And by doing that, he didn't put it to one side and say it's irrelevant. He simply said it wasn't something that weighed with him. And he was right in that conclusion, particularly for the reasons he gave, but also when one looks at the background to what is happening, and if one goes back to the tenancy amendment form, what the council is saying, and what we say it can be inferred Mr. saying was party to, is that the tenancy was moving from joint to sole. Now, as a matter of law, we say that could only happen by the grant of a fresh tenancy. But when one looks at what the parties understood at the time, it would be completely unsurprising if she said, well, here's the tenancy, but I'm now the sole tenant. And so it's completely unsurprising for her to reduce the tenancy agreement, because that's the evidence that, of the tenancy that is now held by her in her sole name. That's how the council understood it in their transfer form, and it would be unsurprising if she had the same understanding. So I don't go so far as to say that her using that tenancy supports the case, but it certainly doesn't undermine it. The only other point I wanted to make is about the sequence of events point. And again, it may be that not a great deal flows from it, given the concession by Mr. Grundy that there's no argument to the effect that if there was a tenancy, then it's too late, because it came post 2012. In fact, the effect would be, if it was too late, it would be fatal to the counterclaim, but it would still mean that the claim for possession would be dismissed, because the council would serve notice on the wrong tenancy, because they serve notice on Mr. Kazan, whereas if there had been a sole grant after 2012, they ought to have served notice on Mrs. Hussain's estate. But
Yes.
But that's a detail. But the point is that even if the tenancy happens after April 2012, it's one factor anyway, but it's only one factor. But perhaps more significantly, the relevance of looking at all the circumstances is that, depending on the facts, they may well relate back. So, in other words, the fact that you look at someone's behaviour as confirmatory of what they what the basis of the party's conduct was, may relate back to an arrangement that happened in the past. And Metcalfe and Boyce is an example of that, where the relevant action happened in 1912. It was only 14 years later that the issue arose, but the surrender still took place in 1912, even though one was relying on matters that had happened many years after that. And of course, it seems to be the case, reading between the lines of Metcalfe and Boyce, that in between 1912 and when Mr. Boyce retired, the Rent Restrictions Act came into force, so it would have been a matter of concern to establish the tenancy that changed in 1912. So it's even taking account of all the points that Mr. Grundy makes about 1912, the significance of 2012, it can still be of relevance to what happened earlier. My Lord, my Lady, can I just check if there's anything else? My Lord, unless there's anything else.
Thank you very much, Mr. Westgate. Well, there's quite a lot to think about. Obviously, it's a second appeal, so it's of some importance. So it will not surprise you to learn that we will reserve our judgments. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says, so it can be distributed only to those on the distribution list, which has been given to the court. Receipt of the draft will be your opportunity to correct our English, but not our reasoning, or to introduce new points. And we would hope that in the light of the draft, you will be able to agree a form of order disposing of the appeal. If you can't agree a form of order, then please make short submissions in writing, and we will make the form of order that we can consider to be appropriate. The eventual hand down of the judgment will be done remotely, so there is no need for further attendance. Thank you all very much for your interest in arguments.